what I'm going to ask Sarah and Angela to talk about are some issues that are often picked up by trust account inspectors that convert to investigations and breaches that we think are worth recounting to you. The first the suggestion is that itemised bills are not being given to a client after a lump sum bill has been given. And Sarah, what's the 30-day rule and the 21-day rule there?
So I see quite a lot of this in the context of personal injuries. I get a lot of the complaints, personal injury-based complaints given to me because of my background in TSC. So I do see a lot of these types of matters where a lump sum bill has been provided to the client's not happy, they ask the practitioner to provide them with an itemised version of the bill, and if they make that request within 30 days of receiving the lump sum bill, then they are required to get that itemised bill from you within 21 days of their request. And it is quite an onerous rule, I guess, and I think some practitioners do find that hard if they sit on that request for a little while and then maybe think, oh, I better get a cost consultant perhaps or a cost lawyer to prepare the bill for me. Then you have to get the file out to them, they have to be given time to prepare it then. So it's quite a tight time frame. And I suppose I wouldn't be so concerned if I see the bill being provided in a short time after that, but it's matters that have gone on for a year or so and the itemised bill still hasn't been provided. And we are seeing quite a lot of that.
And I've had a situation where the practitioner felt really put upon by being asked for an itemised bill because the practitioner either did or was planning to incorporate some sort of a discount in the fees for only being asked to provide a lump sum bill. And in this situation, quite a significant argument unfolded between the practitioner and the client about whether the client was entitled to insist on an itemised bill. The solicitor said, if you're going to insist on an itemised bill, then I'm not doing a lump sum bill and you're going to miss out on your discount. And the solicitor got himself into a terrible pickle by losing his temper and effectively declaring to the client that he'd just done himself out of an awful lot of money because he was going to get a whole lot via the discount incorporated into a lump sum bill because the client insisted on an itemised bill. And unfortunately for you, you have an obligation to provide an itemised bill, and that's just a cost of doing business, especially in a busy practice like you work in at Slater and Gordon. And if bills are relevant to the community legal centres, then in busy CLCs. The second item is clients don't understand precisely. Oh yes, hands up. Please do.
Must the request by the client be in writing?
Sarah?
I can give a bit of context to that, where I had a client's matter settled. The client's mother asked for an itemised bill in writing, and then 3 days later changed her mind and said she didn't want an itemised bill. So I said, can your son please give me something in writing? I'm not sure what you're wanting to do here. And now time has lapsed and I've heard nothing more. So must the request in writing by the client?
I always thought that it did have to be in writing, but until I went back and consulted the Act the other day, I realised it doesn't mention that in the Act at all. I think it just needs to be a clear request. So, I mean, if someone's made it verbally, then I would always be suggesting to them they back it up in writing, put the request in writing to the lawyer, but it doesn't technically have to be, you know. So if they can prove and give evidence to the fact that they, on this particular day, they remember making the request and they've asked maybe 3 or 4 times since then I think that would be sufficient.
The next point is about the problem of confusion in clients between solicitor-client costs and party-party costs. In fact, I know that there'll be people in this room who are confused about solicitor-client costs, and I'm not trying to insult you. It is a tricky area of professional service that you must master. You must master a form of words that describe them clearly to your client when you're talking to your client about how you're going to charge. Your firm in this firm will have provided you with a template costs arrangements document but in many occasions you'll be asked to explain that document. And so we believe that is a very significant source of misunderstanding and complaint coming to our office. Angela or Sarah, do you want to comment on the solicitor-client party-party conundrum?
I am one of those people who often finds it difficult to understand the party-party costs, so I freely put my hand up for that. But yeah, it is an issue. Yeah, it is an issue.
I was just going to add that I've seen documents, like documents maybe entitled authority to settle or something similar to that, where the clients sign up on the day of settlement, signing that they understand what the sister-client component might be, what the party-party costs, how they're going to be recovered, and even a declaration that they understand what the concept. And I've said to practitioners, yes, but does your client understand? Because I'm not convinced. I speak to them on the phone and they're not. They don't understand it at all. So it's all very well to prepare something for your client to sign to say that they do understand, but I guess we put the onus on you guys to ensure that you're confident that they do understand those concepts, and they're hard. I find it hard. But I particularly find it hard to explain to the complainants on the phone, who are lay people who don't understand the concepts. It's difficult.
We often I did at Holding regularly, each of you will have your own sort of set of messages that you would give to a client who wants to know. I used to say, look, part of your legal costs, if you win, part of your legal costs are paid by the other side. And they're called party costs, and so there was a commonality between part of your costs and party. Part of your costs are paid by the other side, but not all of them. A bit like a Medicare gap, where we'll incur expenses or do work that we can't get back 100 cents in the dollar from the other side, even if we're successful. And that proportion I'll look to you to pay. And I'm sure your firm would have routines and protocols where you are expected, upon resolving a litigious matter, which does have a conditional fee agreement, where you clearly set out the monetary amount that your client is expecting to receive, not just make a vague reference to the fact that there'll be party and solicitor client costs, and you'll be receiving an accounting of that at the end of the process. The signing up document is really the money document, where your client needs to understand precisely, if you are able to calculate that at the time, precisely what they're going to receive. Or if you can't calculate that at the time, my recommendation is that you at least get them to sign up for a minimum amount that they will receive, even if there's a bit of uncertainty about whether they receive, out of a $100,000 settlement, whether they receive $85,000 or 90. Probably 90, but there might be, and therefore you sign them up for 85, not giving them any expectation that they're going to receive 90 until you've done the sums. If you can confidently sign them up for 90, and you will say to them, we will then have an argument with the defendant about what party costs we can recover from them, but if we don't recover as many party costs as we expected to, we're not coming back to you to make up the difference. So there are a whole lot of permutations and combinations for you to work through, and descriptions, and did I mention, I think I did, the Medicare gap is often well understood by clients that you could use here. But certainly the confusion that practitioners create about solicitor client costs is almost certain producer of complaints that we will handle. The other point is, you've settled the case for 100, your client's going to get 90, you've signed them up for 90, the solicitor client is therefore 10. You will then come back to your office with great relief and hand it to someone to then go on that terribly laborious journey of recovering the party cost, and that can take, as you know, months. Well, you're still under an obligation to report to your client in writing about what the outcome of that party negotiation was. And many practitioners either forget or wrongly believe that because they've signed the client up at 100, they're going to get 90, solicitor client at 10, that you don't have an obligation to then report to your client about the wash-up. The client may not identify this as a problem, but a trust account inspector, when they see it, will alert you and become alert to an anomaly that could attract a prosecution. So you've got to be meticulous about that. Any comment on the follow-up letter?
No,
Follow-up
I
accounting?
think that trust account inspectors are hot on this issue at the moment. And I've
Because
seen it.
you've spoken to them, they see it a lot,
Yeah.
and they're actually looking for
So
it.
what's one of their focuses at the moment.
Yeah. 7 days notice. 7 days notice are needed for withdrawing money from trust when you're paying a solicitor's bill for costs. You must have a bill. Do you want to expand on that, Sarah, or
Yeah, only just to
Angela?
say that some people aren't aware that the regulations contain this rule as opposed to the Act itself. So if you really drill down into the regulations in relation to trust account and the way you're entitled to withdraw your costs from settlement funds sitting in trust, then
So can we go through a scenario?
Yep.
We've settled it for 100.
Yep.
We've signed the client up for 90. Solicitor client at 10.
The client's agreed to the 10.
And then TAC or the defendant insurer forwards the $100,000.
Yes.
And then what happens?
So then my understanding of the regulations is that the $100,000 comes into your trust account. You do a letter to your client saying we've received the $100,000. Remember that you agreed $10,000 with this lister client. You send that off to them. They get 7 days to think about it and object if they need to. And then at the end of the 7 days, you withdraw your $10,000 from the 100 put it into your office account, and the $90,000 gets sent out to the client.
My first understanding is that you can actually vary that by prior notice in the cost agreement.
Yes, that's right. So I was wondering if someone was going to say that. So the other part of the regulation is the other version of doing it. So if you've got a cost agreement that's compliant with the Act and clearly sets out that you can withdraw amounts such as costs, then you can do it that way as well. But a lot of the cost agreements I see don't have that in it. Yeah, and then that's what raises concerns. Yeah.
And if you don't understand your firm's cost agreement, then make sure you do understand it. There'll be people here who do understand it very well. You've got to find a form of words that allow you to reinterpret that when your client says, I just don't understand paragraph 2, page 3. Please explain it to me. And it's incumbent on you to do that. One of the, I think the themes that we hopefully have touched on during this afternoon is to talk about the approach we take towards regulation of practitioners and towards complaints. Much of it is about educating and minimising the risk of these problems occurring by communicating with practitioners like yourselves. We also find that our complaints handling process requires us to have a very significant empathy for the impact that a complaint and an investigation has on a practitioner. We know we're there for the consumer. The consumer needs a voice. They often need Sarah and Angela and others to communicate the process, describe the work in progress, explain the timetable, provide up-to-date progress reports on how we're going. But what we also must never forget is the disruptive, depressing, upsetting impact that a complaint at all, let alone an investigation by us, has on a practitioner. And we go to a lot of efforts now to try and ensure that we understand the need for speed. We've got to try and bring the complaint to an end point quickly if we can. That's by picking up the phone, by visiting the practitioner, by organising voice contact to perhaps play a bit of shuttle diplomacy to try and manage the complaint as best we can without necessarily investigating it forever. Because we know that long and drawn out investigations that never seem to finish or always continue to pick up new issues that have to be investigated again and again and again are very upsetting and very distracting to a practitioner.